This morning I am going to go over compliance with I-9 and some E-Verify requirements. This is where the employment law and immigration law intersect. And I'd like to go over the components of the I-9 form, common mistakes I see, common practices, and then some policies that are good to implement regarding I-9. So what is the I-9 form? The I-9 form is a form U.S. employers are required to complete for all individuals who they employ in the United States. It's required for all employees. It's required for paid interns. The instances when it's not required are limited to independent contractors, but obviously more often than not, it's required. Some basic components of it, things to be aware of. Non-compliance with I-9 can result in civil penalties, usually in the form of fines that escalate when there's a pattern of non-compliance, a pattern of employing unauthorized non-citizens in the United States. And then there are criminal penalties when it's an egregious pattern of employing unauthorized non-citizens in the United States. It's regulated by federal law. You know, what I wanted to go over today is how to correct an I-9 that's was not completed correctly, retention of I-9s, and the timing of I-9s, because these are, I would say, the three major issues where employers fall into potentially non-compliance. So when does it need to be completed by? The employee needs to complete Section 1 of the I-9 form on the first day of his or her employment. The employer needs to complete Section 2 of the I-9 form within the first 3 business days after the date of hire. I wanted to show the actual form, and this form, I say it's deceptively simple. The instructions to it are actually clear, and they're usually on the form or in the M274 handbook, which I'll get to a little bit later, but it's a very valuable resource in terms of how to complete an I-9 and how to comply with these laws. But it states right on the form, employees must complete Section 1 no later than the first day of employment, but not before accepting the job offer. So employers cannot have candidates complete this form to evaluate if they're authorized to work in the United States and then decide we're not going to make an offer of employment because they're not authorized to work in the United States. So it's not before the job offer, but it needs to be completed no later than the first date of employment. And then let's look at Section 2. Again, right on the form, it says within 3 business days from the first day of employment, the employer needs to complete this section. So retention, how long does an employer need to retain the I-9 form? The law states that the employer needs to retain the I-9 form for every individual throughout the duration of their employment, but no less than 3 years from the date of hire. And then 1 year after the employment terminates, but again, no less than 3 years from the first date of hire. So that means that if an employee is hired, only works for the company for a year, the employer needs to retain the I-9 for 3 years from the date of hire, even though the employee only worked for the employer for 1 year, and the 1 year after the termination is really only 2 years total. The employer still needs to keep the I-9 for 3 years. Corrections, correcting an I-9, this is a question I get frequently. Employers will ask, well, we'll just have the employee complete a new I-9. We'll just rip the first one up and we'll have the employee complete a new one. That's not allowed. You cannot destroy the original I-9. Correcting it is a very specific procedure. The incorrect information needs to be crossed out, and the employee needs to initial that the correction was made. The corrected form needs to be retained, and there needs to be a written explanation attached to the form that explains the error and the steps made to correct it. When these I-9 forms are being completed electronically, which is increasingly we're seeing that they are being completed electronically, there's an audit trail that the electronic forms have that show the trail of corrections. So the incorrect information, the steps made to correct it, and then when the correction was completed. But that's a very common mistake that I see a lot. So then the third step in completing the I-9 is the physical examination of an acceptable document that verifies the U.S. employment authorization. Again, a common mistake is actively or even passively directing what document the employee provides. So there's the list A of acceptable documents, which is a document that both shows the identity of the employee and the U.S. employment authorization, or employees can provide a combination of a document from list B and list C, which again shows identity and the U.S. employment authorization. So if an employer even says something like, bring your passport to work on the first day so we can complete the I-9, can't make that statement, because then you're directing the employee that they have to bring a passport in order to complete the I-9. So the employer can make no statements with regard to what the employee uses to meet this requirement and what document he or she brings. Another mistake that I see is that the physical examination of the original document does not occur. So the employee may bring a photocopy of his or her passport, or a photocopy of his or her driver's license or social security card. That does not meet the requirement. The actual original document needs to be physically inspected, which means that the employee is handing his or her actual passport to the employer or an authorized representative of the employer, and the employer is examining it for its genuineness. Where this issue is coming up more and more is considerations for remote employees. So the last summer, the government went back to the requirement that the document be examined in person. There was an exception during COVID-19 where virtual inspection could occur. That is no longer the case, with the exception of if an employer is participating in E-Verify and is in good standing with E-Verify, then the employer can look at the document over a live video interaction. What that means is they're on a Teams or a Zoom, the employee is holding up his or her passport, the employer is looking at it for its genuineness. But again, that's only an exception for employers who are participating in E-Verify and in good standing with E-Verify. Otherwise, this physical inspection needs to occur in person, and remember, it needs to occur within 3 business days from the first date of hire. Reverification when a document expires. So if a U.S. passport expires, if a U.S. permanent resident card expires, driver's license expires, you cannot ask for a the new copy, the renewed document. Reverification, when a document expires, those documents are really limited to like a temporary employment authorization card. The rules regarding reverification are very specific to the type of document. So that's why I provided these excellent resources that are available on uscis.gov. I-9 Central is very helpful. And then the M274 handbook for employers is very good, and it's very clear on how employers can comply with I-9.
And you said you can't guide people what to grade. The government is saying, look, if you go to column A, you can just have that. But if you go to column B and C, you need both. Right? We're not telling them what to do, but we're saying that you need both.
That clarification is fine, yeah. Like to explain that it's one document from list A or a combination of list B or C. Just not referencing specific documents from either list. Last December, the government released this. This is another good resource on how to avoid non-compliance when you're using an I-9 software program, which again is an increasing trend. Software programs that pre-populate information, auto-populate information, don't allow for certain fields to be left blank. They are not compliant with I-9. So employers have to be very careful in which software programs they use, and as the form clearly states, the employer is liable. They, like Michelle was saying earlier, you can't sort of state that, well, the program was wrong. And then a quick introduction on E-Verify. E-Verify is optional in most cases. That's a question I get a lot is, well, do we have to do E-Verify? No, but there are advantages. E-Verify is a program where you input an employee's information and the government does a cross-check to help verify, like cross-check other databases to help verify that the employee is authorized to work in the United States. My quick bullet points on E-Verify is you can't dabble in it, you can't use it selectively. You have to, once you sign the memorandum of understanding and sign up for E-Verify, you have to use it for every single new hire, and you can't stop using it for a certain amount of time and then restart. You have to commit to using E-Verify, and you have to use it consistently and for everyone. The benefits of using E-Verify, one is that it is a reliable database to show whether the individual is authorized to work in the United States. It's pretty good at doing that check. And another benefit is if you have a remote workforce and you're maintaining good standing with E-Verify, you can do that virtual inspection of the acceptable document over the live video chat to ensure that you're complying with I-9. And then one other important note is that E-Verify doesn't replace I-9. It's not as though you can use E-Verify in lieu of I-9. E-Verify is a separate, most times optional program that works sort of in conjunction with I-9 to help verify that you're employing individuals who are authorized to work in the United States. So I think that is all I have on I-9 questions. Yes?
I was told that we could have a representative of our company, or if say we only had one employee we're hiring here.
Yep.
I was also told that we could use someone else, maybe like a building management or a neighbor, I was told, to verify the document.
It has to be an authorized representative of the company.
Okay.
So I mean, we can speak about this separately. I would not advise using a neighbor or a building manager. But it does not have to be like the specific company representative who does all of the other physical document checks. That person does not need to go fly to San Francisco. You can designate someone else from the company to do that physical examination. Yeah.
If the employee does not fully fill out the form or incorrectly fills it out, could that create liability for the employer?
Yes, yes. It's the employer's responsibility to make sure that section 1 of the form, which is completed by the employee, is completed properly, but the employer can't make those corrections. So the employer would have to go say to the employee, this part was not completed correctly, and then the employee needs to make the corrections.
So we have some electronic employee file, but plus we have.
That's okay. It can be a combination of like a physical folder with I-9s and electronic retention. It can be a combination.